Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
I'm Mary Margaret Bush, Napa Legal's Executive Director. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we will be covering efforts to rebuild free speech for tax-exempt organizations, the reintroduction of legislation to safeguard charities from excessive government oversight, and state legislation protecting religious parents in the foster care system.
All right, well, by the time this runs, it should be Monday or Tuesday of Easter week. So blessed and happy Easter to everyone listening. And what better time as we celebrate this part of the liturgical season to dive into some really interesting religious liberty issues. So let's get to it. So the first topic that I want to cover today is there was a bill introduced in both houses of Congress to attempt to reverse the Johnson Amendment. And I want to just touch base on this because I think not everybody listening, or not everybody in general, unless you practice in the 501c3 world, would necessarily know what the Johnson Amendment is, but everybody knows the gist of it, like what it means. So there's a provision in the IRS tax code known as the Johnson Amendment. It was put there in, I want to say it's 1954. And it basically limits what 501c3 organizations, including churches, are able to do in terms of political campaign engagement in particular. So we'll dive into the history and why I think it's problematic, both in terms of the Constitution and practically, and then we'll talk very briefly about the bill. I mean, the bill is pretty self-explanatory and won't take much time to explore. So first of all, I think the Johnson Amendment is a pretty troubling First Amendment issue. So what this does effectively is say churches and church leaders, right, in their role as church leaders, but churches cannot speak or be involved in conversations directly involving a candidate or a particular campaign or election, but they can speak about political issues, right? So then you have this kind of weird tension where you have to watch what you say, how you say it, and if you touch anything to do with a political campaign, then there are a lot of very close guidelines. We'll get to some of the technical issues, but I think, first of all, to me, this is just I understand the tension, but it's troubling from a First Amendment perspective, right? Political speech is at the heart of what the First Amendment free speech provisions are meant to protect, right? And so churches and church leaders, while they're not primarily political bodies, right, but they don't leave their First Amendment rights at the door when a pastor or a priest puts on his religious hat. He doesn't have to put away his First Amendment rights, or he shouldn't, right? And I think it's worth noting that there is historical precedent for this. I think we're so used to modern 501c3 world that it's like, oh, well, yeah, if you opt for tax exempt status under the IRS, then you can't speak about campaigns. It's what makes sure that 501c3s are not just, covert vehicles for political activity that's tax exempt, right? But it's pretty much a novelty, right? The Johnson Amendment's introduced in the 1950s, and there's a lot of precedent of churches being pretty directly involved in political campaigns that have a moral or religious dimension to them, right? So there's a great resource if anyone's interested in this topic from the Alliance Defending Freedom, their Church and Ministry Alliance section. They published it last year. It's called How the Johnson Amendment Affects Churches. It's a very quick read. It's worth reading through. But it goes through some of the history of church involvement in past political campaigns in American history. And in particular, it emphasizes the re-election of Lincoln in 1864, that a lot of churches were opposed to slavery on moral and religious grounds, and Lincoln was making biblical appeals for the abolition of slavery. This was an openly religious conversation, and a lot of churches were receptive to that and thought that it was in line with their church mission. So there were a lot of churches that were opposed to slavery that openly endorsed Lincoln's reelection, right, in 1864. And the ADF resource points out, if the Johnson Amendment was already in place in the 1860s, maybe Lincoln doesn't get reelected, right? The infrastructure of churches translating their religious ideas into political action, it's not illegitimate, and it has a deep history in this country. So actually, before I go on to some more 501c3 and technical issues, Mary Margaret, do you have any thoughts at this point about the big picture here?
Just to underline what you said, Frank, it's hard to think of a principled reason to limit free speech or condition it in this way. I think it's clearly an outcome in search of a justification. I think you're exactly right. There is a tension here. We don't want churches to become veiled vehicles for political shenanigans, but at the same time, Big Brother can't always step in. And I think this is one of those areas where government intervention is the greater evil.
Yeah, I think that's exactly right. And maybe that helps me pivot quickly to the one thing I want to point out about the repeal bill that's now in Congress. So the bill makes clear that a charitable organization, including a church, can make statements related to political campaigns within its regular course of activities. And I think that just kind of solves the problem, because you're right, Mary Margaret, if a church is just a covert vehicle, right? Somebody starts a church that's basically going to be an arm of a political party, and they're having rallies and they're, hosting interviews with one political party's candidates. It's pretty obvious that this isn't within the regular course of activities of a church. And that's completely separate from, a church has a coffee hour every week after their church service, and they invite certain candidates and they pray with them and maybe even talk about how that candidate's politics are in line with the church's beliefs on ABC issue. Now, granted, that's not allowed under the current 501c3. Just putting that out there. Don't do that right now. But I think the distinction is obvious, right? Hosting a political candidate during a coffee hour or inviting them to a service, praying over them, that's clearly within the regular course of activities of a church, right? Prayer, normal social gatherings, versus hosting rallies and political debates or whatever, or things like that are not within the regular course of activities of a church. I think the distinctions are obvious, and if a church is a covert vehicle and is doing the latter, then I think it's pretty easy for the IRS to pick those out without bothering like a church that hosts a school board candidate and prays over her, right? They're apples and oranges. I don't think you're just going to open the floodgates to, political action committees pretending to be churches. So the other thing I wanted to say is going to 501c3 status. Again, in our modern framework, we can look at this in a way that I think is wrong, right? So, of course, 501c3 status, it's not a constitutional right in itself, right? The right to be tax exempt under the IRC, but conditioning tax exempt status on giving up certain constitutional rights like freedom of speech on political issues, it's a problem. And I think that part of the problem is that we've become too used to maybe looking at tax exempt status as like a benefit that the government gives out of its, kindness, as a special optional benefit if you follow its rules, which obviously there are rules that you have to follow. There's a tax code, but I think the way we've typically talked about tax exempt status is it's an acknowledgement. It's a reflection of the reality of what a church or a religious or charitable organization is, which is an entity that exists to do something other than create a profit. And so it's not a proper subject of taxation, right? That's how I tend to look at tax exempt status. This is more a recognition of what the entity is, and not, a grant that the government can just give and take kind of arbitrarily. So to me, again, this looks like another attempt to cabin religion. We've talked about this in some past episodes on some various cases, to make religion something separate from political life, right? You can have your worship services, you can have your religious groups, your churches, but that can't filter into political life at all, right? If you're a church, you don't talk about campaigns. That's not your wheelhouse. And I think that's an artificial divide between religion and all the other parts of civic life, right? The reality is religious belief affects the political opinions of Americans, and it should, right? Because if you have deeply held religious views about the dignity of human life, about what the human person is, about what sexuality and marriage are, of course that affects political decisions. Of course that affects the way you vote, because if you think that a particular issue has really good or really bad implications for a society, based on your religious principles, that's part of what you bring to the table when you pick candidates or when you vote, right? So at least to me, forcing churches not to speak about how their religious beliefs translate to politics, even in the form of specific candidates or campaigns, I think that's an artificial separation that doesn't really, it's not really appropriate to put such drastic restrictions on churches. Because the reality is, right, some candidates will represent the values of a church. Other candidates might be directly opposed to core values of a church. So why shouldn't the church be able to kind of speak those truths directly and say, like, hey, this candidate is supporting XYZ. As you all know, that's a key part of our beliefs of what's good for the person and good for society, versus having to play this indirect game where it's like, okay, the church can talk about political issues and say, remember, as a church, we're against this or we're for that. And, you kind of just say it indirectly and hope that your congregants get the message and will vote the right way. You're kind of forcing churches to talk about important translation of religious beliefs into political action indirectly to kind of skirt the current rules that are the result of the Johnson Amendment. I have one more thought about that, but Mary Margaret, do you have anything else on this, or should I clean up here?
Yeah, I think your comments are great. Yeah, please
All
keep
right.
going.
So the one thing, and this we'll plug here, if anybody's interested in this, we published a resource last year. I used to have it up, but now I don't. On political activity, lobbying, and 501(c)(3s, and it includes a template, like a sample policy of how religious organizations may want to treat these issues under the current IRC framework. So read that. But I went back and I was reading through that, and my other problem is the way that it stands now with the Johnson Amendment. The current rule is very tricky. Not only because I think it's wrong to limit churches and take away their First Amendment rights when they put on their church hat, but also because practically, I think it's kind of a fraught exercise to have to speak about political issues, which 501(c)(3s are free to do, but not at all about candidates or campaigns, which they're not free to do, especially during campaign season. And there are some IRS resources that particularly warn you that this is a dicey, line to tread. There are a couple of TAMs, or the technical advice memoranda from the IRS, that talk about, their fear that 501(c)(3s are using surreptitious ways of engaging in campaign activity, but masking it in the form of issue advocacy. They talk about using code words, that maybe a church will talk during election season about a political issue, not a candidate, but just a political issue, and then slip in words like liberal, conservative, pro-choice, anti-choice, Republican, Democrat, in an effort to like covertly tell their congregants who to vote for, right? So it's kind of covert campaign activity. And I think, to me, again, this is a real problem, because 501(c)(3s have the right to talk about issues, including very political issues, right? Abortion, same-sex marriage, adoption, you name it. But during campaign season, you're kind of being signaled that, well, if you do it in a way that makes us think that you're maybe telling your congregants who to vote for, then you might be jeopardizing your 501(c)(3 status, right? So not only do I have a problem in principle, but I think practically it's too much to tell people to navigate this line. Like, yep, you can talk about politics and political issues all you want, just don't name a candidate and don't use any code words that might make us think that you're naming a candidate. And I don't think it's appropriate. I guess that's a long roundabout way of saying, bravo to Congress for introducing a repeal. I really hope it goes through. I think that restores some common sense First Amendment protections to allow churches to speak about key civic issues.
Yes, Frank, that's so well put. I think the Johnson Amendment is problematic for its legal reasons, but it's also harmful for culture because the law is a teacher. And so by stigmatizing the civic engagement of religious groups, we devalue their right to free speech and a slew of their other rights. So obviously this is wrong in itself, but I think it also has significant harmful downstream effects. If you look, like you said, so many of our problems throughout American history have been tackled and solved by faith groups. The civil rights movement, not the least of which, it was deeply religious and incredibly fruitful in repairing some of our country's greatest sins. So the entire mentality motivating the Johnson Amendment is so problematic. And building on that same theme of attempts for government control or limitations of faith entities and civil society, we have some good news. Oklahoma Senator Langford and Florida Representative Stubbe have reintroduced a bill protecting the freedom of 501(c)(3 organizations from excessive government interference. So specifically, this bill, the Safeguarding Charities Act, clarifies that tax-exempt status is not federal financial assistance. This matters because while exempt status is simply the absence of taxation, federal financial assistance is proactive government aid that comes with reciprocal obligations to the government, including obligations to adopt the government's policy positions, often on sensitive issues, and submit to extensive oversight. Proponents of big government have been taking aim at the autonomy of tax-exempt organizations in this area, especially faith-based organizations, for years, attempting to bring these groups, which we often collectively call civil society, more deeply under government control. This bill, the Safeguarding Charities Act, was first proposed in January 2024, and support fell pretty much along party lines at that time, with Republicans, including J.D. Vance and Marco Rubio, co-sponsoring the bill. But the shoe is on the other foot now, as Harvard University's tax-exempt status is now being questioned after allegations that its lukewarm opposition to anti-Semitism violated protected classes and their obligations under their federal financial aid and their status as an exempt organization. So the arguments against Harvard follow a slightly different tactic than the issues addressed in the Safeguarding Charities Act, but the same principles are at play. Their financial assistance has already been frozen, as a side note, with more than $2.2 billion in grants and $6 million in contracts paused or permanently canceled. So we'll see if the bill now gets bipartisan support, with secular institutions along with faith-based and traditional institutions clearly impacted here. Frank, I know you and I have talked a lot about this, particularly because Napa Legal filed an amicus brief in the Baltimore Lutheran case that dealt with these issues a few years back. What are your thoughts on this bill, the timing, and what we might expect going forward?
Yeah, this is a really good one, and you were, I think it was you originally who were pretty prescient about this when this first started coming up with the Baltimore Lutheran case in the Fourth Circuit and this string of issues that made this statute or this bill necessary, and that this should be a bipartisan issue. You had said this at the beginning. It wasn't at first because the 501c3s that were under attack were on one side of the ideological spectrum, I suppose you could say. But I think we always saw this coming, right? It's like, well, if 501c3 status is a government benefit that's all of a sudden going to make a nonprofit, fall under the Civil Rights Act and all these various other compliance regimes at the federal level, there I would think would be nonprofits on both sides of the political spectrum, the religious spectrum that don't want this, right? So you're right that now that Harvard is in the news and the shoe's kind of on the other foot, as you said, that now I'm hopeful that this will be a little bit more of a bipartisan issue. Remains to be seen. And connecting this to the last topic, that's the only other thing I'll say here is that what you said goes along well with what I just said in the last one. That I think this bill, while it shouldn't have to be introduced in the first place, because to me, and I think probably to you as well, the fact that 501c3 is not a government benefit is just common sense. Like it's just not the same thing, right? And government benefits are grants, funding, like dollars being given to you, not recognition of your tax exempt status. It's just a completely different thing. It's kind of unfortunate when you have to spend political time and capital codifying common sense, what's already in the federal code, but you have to do it at this point when you've had legal challenges in multiple circuits now claiming that 501c3 status is a government benefit. Then yes, this makes sense. It's a great idea. And I think what it does is it clarifies what we were just saying earlier, that 501c3 status is not this thing that the government can confer or take away arbitrarily. It's a recognition of what an organization is. And so if that's what 501c3 status is, then it's clearly not a government benefit that triggers all of these federal compliance items, right?
Yes, Frank, that's exactly right. In fact, I remember from the oral arguments in the Baltimore Lutheran case in the Fourth Circuit that one of the judges pointed out that under the big government sort of theory of tax exempt status as federal financial assistance, every single taxpayer would be subject to Title IX and a deluge of other regulations every time that the person received a tax deduction. So even just taking the standard deduction would make every single one of us subject to Title IX, which is laughable, but also being seriously argued. And the other thing that came up when this was going through kind of the judicial system rather than the legislative side was that the big government proponents of including tax-exempt status and federal financial assistance, they came up against religious liberty arguments about how the regulations that would be triggered would violate religious liberty. And they cited to certain exemptions, for example, in Title IX. Well, at the same time, those same parties were challenging the Title IX exemption. I believe it was out in the Ninth Circuit in the case originating in Oregon. So the amicus were signed by the exact same state's attorneys general in both cases. So they're both saying, don't worry, there are exemptions. Also, our right hand is challenging those exemptions. So it was definitely a 1-2 punch. And I won't say it was a conspiracy, but I'm just saying the parties signing both were the same. And so there was some coordination taking on that was pretty troubling.
Well, we're hopeful on both of these issues, right? These kind of course corrections at the federal level to some 501c3 issues that we care deeply about. I think then we'll close by turning to some good news on the state level. So this is there are two states that have recently enacted laws that we wanted to highlight regarding fostering and adoptive parents. And this is I'll talk. I think I'm going to go a little less constitutional technical law here and a little bit more some personal anecdotes because I've worked in this area in the past. And I think there are some things at play that a lot of people don't really see. This just looks like another hot culture war issue between Democrats and Republicans or what have you. But I think there's some misleading stuff buried in these fights over essentially Christian foster parents. So the Kansas legislature recently enacted a law that prevents unlawful discrimination against basically religious foster parents. The governor in Kansas vetoed the bill, and the Kansas legislature overrode the veto, so it's now in effect. And there was a similar bill recently signed into law in Arkansas. So what both of them do is essentially state that an individual or a family cannot be denied the opportunity to be a licensed foster parent, a foster home, because of their sincerely held beliefs, particularly about gender identity, sexual orientation. And these things are important. But well, first of all, the caveat, both state laws, which I think makes sense, but they note that the state or the licensing agencies, and that's an important distinction we'll get to in a second, but you can still take a potential foster parent's religious and moral beliefs into consideration when determining a specific home for a specific child. I think that's right. And again, I've worked in children and youth before, so that makes sense to me, right? Maybe we'll just touch that now, because I think you need to understand that, right? So if you have, let's say, a teenage child who needs a foster home and they've adopted a trans identity, right? They come from completely non-religious home and upbringing, and that's the life they live. While obviously as Christians, as religious people, we probably have a lot of concerns about that child's identity and lifestyle being affirmed. Placing that child in a very conservative, like Orthodox Christian household when the child's already a teenager, probably not a good fit, right? It's probably not going to go well, right? And then on the flip side of that, like if you have a young child whose parents are Christians, right, believing Christians, but they've fallen on hard times for whatever reason, they can't care for their child, they want a foster home, you should absolutely be able to take the parents and the family's preferences and say, we'd rather have our child placed in a Christian foster home, right, where our family beliefs and practices can be honored and continued as much as possible, right? So I think it's important. I don't think that these questions of religious and moral beliefs should be excluded carte blanche in either direction from foster licensing considerations. I think they're from foster placement considerations. But the problem is that you have states and state regimes that are, instead of making that case-by-case decision, are actually saying, no, you have to sign as a foster parent a statement saying that, if we take a child into our home who has like a sexual orientation, gender identity different than what we feel comfortable with, like we'll embrace it or we'll accept it, or the wording is going to be different case by case. But that's a huge problem, because you're discriminating against a whole host of religious people from being foster parents, right? So huge religious free exercise, free speech issues here. The next thing I'll say is that so I'm glad to see these non-discrimination kind of statutes being put into place to say, no, you can't just not license people who have these beliefs. That's a huge First Amendment issue. It makes sense that the state is cracking down on that. I'll be interested to see how enforcement plays out, because a lot of people don't realize this, but usually the way the system works, it varies by state, but states make the foster licensing criteria, right? They say, to be a foster parent, you need this many bedrooms, you need to pass, whatever disability, you need a safe house. You have all these criteria that, water test, all these things to make sure your house is safe and that the parents don't have a criminal background or whatever. And then you can get licensed. But generally the state doesn't actually do the licensing. They shop this out to private, agencies, foster agencies, that they are licensed by the government, and then they in turn license the foster families. And I think that's relevant because it's one thing for the states to have their criteria. It's another thing to see on the ground how those licensing agencies actually apply them. And this is not confidential, so I can say this briefly. But when I was working for a children and youth agency, there was this list, right? You have to do A, B, C, D, E, F, G to be licensed as a foster parent. And during COVID, one of the foster agencies that we were working with refused to certify someone because of their vaccination status, their COVID vaccination status. And we went back to the foster agency and said, "You're not allowed to do that. Like, there's a limited list of criteria that license you as a foster uh, parent, and you as a foster agency have to implement those. You can't add new ones." That was our argument. We ended up just using a different licensing agency, but so I'll be curious to see how this works on the ground when Kansas and Arkansas say you may not discriminate against religious parents because of their views on sexual orientation, gender identity. Hopefully that will be abided by. But it's a real question. Like, these kind of things get tricky on the ground. And then the other thing I'll say is, besides the principled problems here, this is just practically so tragic to see states that are trying to exclude foster homes because of their religious beliefs on these certain issues. Because, for one, most places have a huge shortage of foster families. So I remember, again, when I was working in the agency, we would have a hard time finding foster parents for kids, right? So to say we're going to exclude a group of people, not because their houses are dangerous, not because they're not fit to provide for foster children, but because they believe XYZ about sexual orientation and gender identity, it's just a huge disservice to really disadvantaged kids who need loving homes. And loving homes are being turned away because of these licensing regimes. So again, bravo to Kansas and Arkansas for saying, no, you can't do that, because, again, there are shortages. And the other thing, and then I'll stop talking. Sorry, this is a little bit of a soapbox issue for me because I've worked in this again. But the other thing is that excluding religious foster parents carte blanche from all fostering because of their beliefs about, like, how they would treat, somebody with an alternative gender identity or sexual orientation or whatever. It's an answer to a problem that really need not exist, because foster parents, when they're licensing doesn't mean you therefore, like, have to take the next kid that the agency says, oh, this kid has been removed from his home, you need to take this one. Like, foster parents have wide discretion to say, like, we really only want to take kids who come from a Christian home, or we really only want to take kids under 3 years old because we just aren't comfortable with teenagers, right? So if that's the situation, then the SOGI issue for a lot of these Christian families, it'll never come up, right? Like, it's one thing to say, well, if you're not on board with, the trans movement, the trans ideology, that we're not going to place a troubled teenager in your house, fine. But a lot of these parents might not even be open to taking teenagers. And if it's a baby, then what they think about trans ideology has nothing to do with how they're going to foster this baby over the next year or two, right? So to me, it's you can just refuse to match these families with certain kids when you don't think it's a good fit. That's what's in these bills. That's the right way to deal with these cases. But the exclusion of religious foster parents per se, to me, it can't be anything other than an ideological stand, because it's not addressing a real issue.
Frank, your insights coming from the practitioner standpoint are so interesting, and I think it's very refreshing and insightful to hear your perspective, because I think your perspective is so nuanced. You understand this is about the best interests of the child, and it is no place for a culture wars ideological standoff. There are kids who are not going to get homes if we turn this into some kind of grandstanding effort. Um, I had 2 points, one on the legal side and one on the cultural side. I'll just start with the cultural side. I think these laws are a great step forward. Continuing our theme earlier of these different legal regimes that really stigmatize people of faith, suggest that they can't provide loving and safe homes, suggest that they can't be part of the system or the solution at all. And that's just culturally, I think it's almost perhaps even more harmful on the cultural standpoint than the mere legal and technical standpoint, by sending this message that people of faith are a problem. So that's a really big issue. And so to see, and I know that that's taken place in Vermont, Washington, Oregon, that issue has come up. And so it's great to see Kansas and Arkansas showing a productive side of it. And then I guess on the legal point, I'd kind of be curious your reaction to this. My first thought when I see religious freedom in foster care is Fulton versus City of Philadelphia. And at first I thought, well, wasn't this addressed by Fulton? And I wanted to just outline kind of how this is distinct and what areas of religious freedom are sort of still at play here. So the Fulton case involved a Christian foster care agency that was declining for religious reasons to certify same-sex homes as placements for kids in their agency. Those couples did have opportunities to certify through other providers, and it was presented in the case that no one had sought to participate in the foster care system and been declined an opportunity to do so. It was simply an effort to compel one faith-based foster care agency for operating according to their beliefs. Here we have a different situation, like Frank said, where people of faith are being excluded from the foster care system per se at all, not even declined by certain agencies or referred to other agencies, but actually declined, denied an opportunity to participate. And so it's much more extreme than what was done in Fulton, slightly different sort of from a fact pattern standpoint. And I look forward to seeing this resolved. I don't know if do you have any thoughts, Frank, just connecting the dots with this in Fulton, what's different, what's the same, and what needs to be decided here?
Yeah, it's been a little while since I've read Fulton, but you're right. Your analysis is right. So that was about one particular agency being discriminated against for being a Christian agency and refusing to license to do certain things, right? And the argument was, well, right, the counter is you're free to go elsewhere, right? There are other foster agencies that will, certify. You don't have to go pick the Catholic one and be mad that they're living out Catholic values. This is, you're right, the extent of the problem is different in these kinds of cases. And I would also say that the solution by states like Kansas and Arkansas is actually broader than what Fulton gives, right? Because this isn't just saying a Christian foster agency has the right to live out Christian principles, but this one is saying, like, no, you may not have a foster criteria that is infringing on religious liberty, no matter what, whether you're a religious or a secular licensing agency, right? Like, just our licensing criteria does not include discriminating against Christian beliefs, period, right? So again, you're right. The problem is worse and the solution here is broader. So this is, I think, another important next step in the rights of religious exercise in the foster and adoption world.
Thank you, Frank, and thanks to all of you, our listeners, for joining us for this episode of the Napa Legal Podcast. If you enjoy our content, please like and subscribe on YouTube, Spotify, or wherever you're listening. Please join us next week for more updates on today's most pressing issues facing religious liberty and civil society.
We'll talk to you all next week. So thank you for joining us. Happy Easter. God bless you all.